Thank you all very much for a brilliant, brilliant discussion, which I think will set us up nicely for the rest of the day. Alana Powers, people, everyone. Sorry, Alana Powers O'Brien. I stand corrected. So now we have a very special guest with us today. Andrew Ferguson is chairman of the Federal Trade Commission. He most recently served as Solicitor General of the Commonwealth of Virginia. And prior to that, he served as chief counsel to Senator Mitch McConnell and as a Republican counsel on the US Senate Judiciary Committee. He also practiced law at several Washington, D.C. law firms. And sitting down with the chairman is Cecilia Kang, who is an award-winning technology correspondent at the New York Times with an expertise in the intersection of technology and public policy. Cecilia has over 20 years of experience in journalism covering US and international technology, economics, and business news, including 7 years at the Washington Post. So please welcome Chairman Ferguson and Cecilia Kang.
Well, hello, Chairman.
Morning.
Welcome, good morning. And quite an audience here. I'm sure they're very eager to hear from you. So I'll get right into it. After that presentation, I think we should just go right into AI and chatbots. And at the FTC in September, you launched an inquiry into AI chatbots. Can you talk a little bit about generally how you're approaching AI, newish technology, a lot of the same issues that we've seen around children and safety and teenagers and safety? How are you thinking about AI and chatbots, and what do you hope to achieve from this study?
Well, thanks for having me. I'm really happy to be here. So I'll talk about this a little. I want to resist slightly. There are a lot of the same issues with AI that we have with other technologies, but this technology is unique in one important way. So as the internet sort of began flourishing, the internet basically made it possible to do more quickly and more efficiently things we were already doing. It made commerce more quick and efficient, made communication more quick and efficient. AI is different. You couldn't have necessarily predicted the direction in which the internet was going to go, but it was taking things human beings were already doing and just basically eliminating a lot of transaction costs and searching costs. AI is different. The people creating it don't know really what it is. They're often surprised by their own work on it. They don't know which direction it's going, and neither do we. And as a regulator and law enforcer, if you don't know the direction in which the technology is going, my instinct, I think this is one of the ideological questions that voters will get to decide in upcoming elections is, in the face of new technology, do we want sort of regulatory ambition or regulatory humility? And my view is, in order to let the technology develop, and in order to make sure that the United States stays at the forefront of the development of this technology, and that the innovation doesn't shift somewhere else, particularly to an adversary, we need a touch of regulatory humility. You can sort of look out over the globe and see how different polities are handling the same question. Europe has decided, we want comprehensive regulation sort of at the nascency of the technology. I think that's a terrible mistake. And I think generally the United States' view is what its view has been for a couple centuries with new technology, which is we're a country of pioneers, we're a country of innovators, we're a country of risk takers. And that's why we've been sort of the engine of innovation and development for the whole world since the late 18th century. But in order to keep that, the regulators need to take a somewhat, a hands-off approach, step back and say, the developers don't know where this is going or what it is. We don't know where it's going or what it is. If we sort of come up with a scheme of regulation aimed at something today, by tomorrow, it will have lapped us already. Now, I think that that's sort of the default approach, but we also don't want to sort of create a system where the trade-off for innovation is children, where that ends up being sort of the grist for the innovation mill. And so, at the FTC, I've got, a couple powers, the ones you read about in the newspaper all the time. I can sue people if they're breaking the law, and I have the power in some limited circumstances to issue regulations. The third power that is not talked about as much, but when Congress created my agency, they understood to be just as important as sort of the direct law enforcement power, is this 6B power that you mentioned under 6B of the statute, which gives me the power effectively, I'm going to reduce it to layman's terms a little, but effectively to issue subpoenas to businesses to require them to turn over information of the type they would turn over in a law enforcement investigation, but not for the purposes of me bringing a law enforcement action, for the purpose of me writing a study, releasing that study to the public, to Congress, and allowing that study to inform policy choices that Congress is going to make, or that the states are going to make, or that other parts of the federal government are going to make, including the FTC when it decides whether and how to enforce our very generally worded statute, Section 5 of the FTC Act, in this new context. So the 6B study we issued a couple months ago went to basically most of the major AI chatbot developers and said, we want data from you, not just data, we want documents on how your chatbots are affecting children. What research do you have on it? What safeguards do you have in place? How do you understand children to be interacting with these? What effects do you understand them to be having on children? And are you doing anything about the data you are collecting on children? And that is sort of consistent with, I think, President Trump's general approach to AI, which is embodied in the American AI Action Plan, which is we want to win the AI race against our adversaries. America's sort of competitive advantage is a hospitable regulatory climate. We want to foster that hospitable regulatory climate, but we have to continue protecting American families and especially children from the development of this technology. So the point of the study is to figure out what is in fact going on in this rapidly developing technological landscape. And then once we understand that, that can inform both regulatory and policy-making choices and inform how we at the FTC understand enforcement of our very generally worded Section 5 statute to protect children and families. So, I think the 6B is sort of the perfect approach here, which is understand before enforcement. I think blindly racing into regulation or enforcement is very likely to have second-order effects that we will regret. But proceeding with enforcement once we have a good understanding of how this works, and also giving Congress and the states an opportunity to see how it's working as they are making their own regulatory and policy choices, I think is the best way to proceed.
So I'm reminded with the last 6B study that I watched the agency pursue was related to antitrust and tech companies. And that did lead to several lawsuits at the DOJ and the FTC. So it was clear after that study that there was not only legal authority, but there was action taken. So talk about your legal authority, actually, when it comes to kids, from what you see so far. If you can tell us a little bit about what you found so far in your 6B, that would be terrific too. But generally, what is your authority when it comes to, when you see generative AI chatbots and Section 5, what are the limits and potential gaps you see so far?
We're two things on the 6B study. We're very early. The data is only just sort of starting to arrive since we just issued the orders. And generally, as is always true when the federal government issues non-criminal compulsory process, you ask for a lot, and then there's a series of negotiations where the company says, what exactly are you looking for? Because we know what we have and you don't, and so we're working through that. We also don't release any of the information we get except in the written reports. So I don't know exactly when that will be. We tried to make the study broad enough to get at what we care about, but limited it enough so that companies can turn over stuff relatively quickly without us having, for example, going to court to enforce the 6B orders so that we can get the study out there. In terms of our legal authority, I'm going to divide it into basically two buckets. The first is privacy. The whole internet is sort of built on this exchange between us and companies on the internet, where we normally, for a lot of the services we use, we don't pay dollars for their use. We instead hand over a lot of private information about ourselves. That sort of happens in the background. You don't really know that you're doing it. Consumers have gotten more sophisticated about this in the last 10 years, but generally this exchange is happening so in the background that even a consumer aware of it is not aware in the particular moment that every click, every keystroke is providing data about the user to the internet company. But that's sort of how the internet economy is built. We're not, I'm a DuckDuckGo guy, but if you're using Google, for example, you're not laying down your credit card in order to do a search, but you are turning over troves of data to Google every time you conduct a search so that they can monetize that through advertising. And so Congress, we do not have a general federal privacy law that's been the subject of political dispute now for a long time. But we do, dating back to 1998, have a privacy law aimed at protecting children, the Child Online Privacy Protection Act, or COPPA. And the FTC has promulgated a rule, which it has updated from time to time, including just this year, aimed at protecting children 13 and under online. So that's the first one. We've already brought a bunch of COPPA actions since I became chairman. One of the first things I told the staff in January when the president appointed me to the chairmanship was bring me COPPA cases, as many COPPA cases as you can find. Yes, there are inadequacies in COPPA. It was a law written in 1998. It's 2025. There are definitely inadequacies, but we ought to push this thing to its absolute limit and protect as many children in as many ways as we possibly can. We are right now looking at additional amendments to the COPPA rule that we just updated in 2025. So this is one of our highest priorities. So that's sort of the privacy bucket on the children's side. Right. The FTC has, over the course of the last 20-ish years, depending on which one you consider our first one, developed what experts call the common law of privacy. There have been dozens of cases that the FTC has brought under Section 5 about data security, actual privacy, like the hoovering up of data by companies from consumers. We almost never litigate these. We actually have only really ever litigated one, and we're litigating it right now. It's called FTC against Kachava in the District of Idaho. Most of these have been consent decrees. And through these consent decrees, the FTC has sort of established what it understands Section 5's privacy rules to be. And for those who are not familiar, Section 5 is an incredibly generally worded statute for purposes of the area we're talking about right now. The prohibition that Congress added to the FTC Act in 1935, that's how old this is, prohibits unfair or deceptive acts and practices. That's it. That's what we're working with. A 1935 law that has those 9 words. And so a lot of our work has been in deception. In other words, internet companies make representations to consumers that they're going to protect their data a certain way, they're going to use their data a certain way, they're only going to collect certain types of data. The FTC learns that that's not true. That's relatively straightforward. The trickier one is unfairness. As a very famous judge in New York once said, unfairness is in the eye of the beholder. And so the FTC has sort of tried to figure out what the bounds of unfairness are when you're collecting people's data. But that's sort of the buckets of our privacy authority.
Let me put a pin on this this thought of deception. I was so interested in the study that we just heard about, where one of the panelists talked about how 42% of teenagers believe they're talking to a human when they're talking to a chatbot. And I'm following a lot of these cases in California on social media and really basically like faulty products, deception around algorithms and addiction and feeding. And I see them kind of in the same sort of bucket, if you will, or at least click to me. What are your thoughts on when it comes to the design of a product, when it comes to how children are perceiving the technology they're encountering, such as chatbots? When I talk about design, I'm talking about social media, and a role for the FTC as this litigation goes forward in these cases.
Yeah, so this is sort of the ongoing debate being had on both sides of the Atlantic is, do we care mostly about policing sort of representations that a company makes to a consumer, both like affirmative representations about a product, but also sort of the sotto voce ones where there's like a known understanding between the consumer and the business about what the product is. And is that known understanding an honest one? Traditionally in the American legal system, you're only sort of liable for things you affirmatively represent to someone else. You may have heard the phrase, if you've ever bought a home, caveat emptor, buyer beware. The only thing that you are ever required to warrant is that what you've told the person is the truth. But when Congress passed the provision of the FTC Act we're talking today, one of the things they said was that they wanted to relieve the American people from the onerousness of caveat emptor. And so generally, Section 5 applies both to things you affirmatively warrant, but also to things you should have told someone. If a reasonable consumer would have expected to have been told about something, failure to tell them violates the FTC Act, even if it wouldn't have violated sort of the general American common law principles that we had before 1935. So one of the things we look at in all sorts of cases, including our privacy cases, is not just what did you tell a consumer, but what did a reasonable consumer expect from the transaction when they entered into it? And if you, the business, were not acting consistently with a reasonable consumer expectation, did you tell them that you weren't going to? And if you didn't, that is potentially a problem. Now, it is harder for the reason I just said, which is it's inconsistent with sort of the long tradition of Anglo-American law to prove an omission case than a commission case. In other words, it's much easier to prove that someone said something to a consumer and was not telling the truth than they should have said something to the consumer and did not, because you first have to have an understanding about what a reasonable consumer really would have cared about entering transaction. And this is actually one of the trickiest things in privacy is study after study after study, including very recently, have revealed that even when consumers are aware that their data are being hoovered up at an incredible rate, it wouldn't change the way that they're behaving with internet companies. And you can see this in particular where there are companies that will provide services identical to the free services being provided by major internet platforms for very small fees. And they have a hard time competing with the big guys because consumers, at least to date, they are more privacy conscious and they've priced their privacy higher than they did 10 years ago, but still not to the extent that, for example, I do. I'm like an idiosyncratic consumer. I'm Proton everything, DuckDuckGo. But the average consumer doesn't feel that way at all. And study after study revealed that even when they're told, they wouldn't probably change their behavior. And so trying to figure out what is material to that consumer is difficult. And that's true in the chatbot space as well. But chatbots are interesting because the promise of AI as it's delivered to the American people is cures for dementia, cures for cancer, the next generation of American weapons that will assure dominance in the Pacific Basin against our rising rivalry with China. That this is the thing that pushes us, past the horizons as we currently see it. But it sure seems that an incredible amount of this capital is being invested in these chatbots. Yes. And the chatbots primarily are another mechanism for hoovering up data. So I remain optimistic that the grand investments in the sort of the horizon shifting technologies are happening, they're coming, but a lot of the emphasis seems to be on chatbots, which is why our first major sort of policy regulatory foray into the AI space has been on chatbots. With one exception. We have brought enforcement actions against AI companies that have made false representations about what their product can do. Yes. So you will find, if you Google, I want an AI for fill in the blank, almost anything human beings do, there are companies that will purport to provide an AI thing that will help you do whatever you want to do purportedly better than you can do it now. We have found that not infrequently, the representations those companies are making are wildly inaccurate. And we have brought lawsuits against AI companies and have consent decrees against some of these companies where we just said, you said your product could do this and it was a categorical lie. You can't say that anymore. So we've done a fair amount of enforcing in that front, but that's treating AI like every other technology. Yes. Like, if you say you have a pencil that can write in multiple colors and it can't, that's an FTC Act violation.
We will have time for one question, and I know this time is just breezing by really fast, but I have to follow up on this. Oh gosh, I have like 20 questions. When you think about, you've been a real critic of the power of the biggest technology companies, and many of those companies are poised to be the most powerful companies in AI. How are you thinking about competition in this space as it intersects with what we're talking about today?
Yeah, it's a good question. Two things on that front. First, I think one of the One of the promises of AI, which I think is even more true today after the revelation that DeepSeek was, DeepSeek overstated how easily it trained its LLM, but now that we realize you don't necessarily need, a billion GPUs and $10 billion to train an LLM, one of the promises of AI is that startups can challenge the big tech incumbents for the first time in quite a while if you can build an LLM that does very well. So I think AI has a fair amount of competitive promise because it's an injection of a new technology into an ecosystem that had come to be dominated by a handful of very large companies that were sort of doing the same thing for a long time. Yes. So in terms of making sure that we realize the benefits of that competitive promise, I think I have two things in mind. The first is the inputs for AI, sort of the physical inputs, electricity, physical technology like GPUs, the inputs for GPUs, testing for chips. We just had a giant settlement in a multi-billion-dollar merger for a company that helps people train or helps people test chip-based technology, which is a super important input into AI, is making sure that those markets remain very competitive, because what we don't want are like competitive bottlenecks where one or two companies comes to develop a monopoly in some important input and can raise the cost of everyone else who's creating AI technology, which consumers will pay for in one way or the other. And I think the second is, we don't want companies illegally creating some monopoly or using AI to entrench an existing monopoly. Obviously, a lot of these AI firms need computing, and the computing power is possessed by the big technology companies. It just is what it is. The hyperscalers have the technology that they need. But I will say I'm optimistic about how rapidly the technology changed. Just like 2 years ago, I heard lots of complaints from startup companies about hyperscalers, and that they would get locked into these contracts with hyperscalers that were very sticky. It was very hard either to leave one hyperscaler and go to another. It was very hard to house your data across multiple hyperscalers. Well, now there's a bunch of technology that allows you to house your data across different hyperscalers and just tap into it as you need it. It didn't exist a couple of years ago. And the contracts changed because the hyperscalers got so competitive on price that now these same companies were telling me, actually, this was a problem, it is not a problem. It got technology, new competitive pressure. We now are able to sort of like play each hyperscaler off each other. We're able to move quicker. And it's sort of like the AOL phenomenon where, in the 90s, everyone was very animated about a potential AOL monopoly, and AOL is no longer, literally doesn't exist. And so, we are very vigilant about inputs into AI. We're very vigilant about making sure that the big tech companies don't use AI to entrench their monopoly. But I also think it's important that we don't just go charging ahead.
Be patient.
This technology changes so quickly. And I've talked with even my foreign counterparts about this. And they also have learned, hey, if we intervene at point X, we will be at point Y so quickly that by the time our intervention is concluded, it won't matter anymore. So be watchful, be vigilant, but choose your spots carefully.
Thank you, Chairman. There's a jam-packed answer. I don't even know if we have time for, do we have we do not have time for a question for the audience. So sorry, I hogged the mic. Thank you so much, Chairman, for your time, and you were very informative.
Thank you.